Welcome to the deep dive. Today, we're looking at a stack of source material that is, frankly, as uncomfortable as it is necessary. An incredibly exhaustive collection of documents with us.
Right.
Everything from internal prison memos and shift logs to, FBI transcripts and even sealed court filings. And it all covers the two big eras of attempted accountability for Jeffrey Epstein.
And our mission here, I think we have to be really precise about this. We are not interested in the shock value.
Well,
The headlines of, they already covered that part. We're here to conduct an investigation into the paper trail itself. It's like a forensic audit of the system.
a moral audit.
A moral audit, exactly. This whole deep dive is fundamentally a story of how institutions fail. It's a chronicle of human systems failure. And we're focusing on the enablers, the silence, the institutional inertia, and these huge power networks that just surrounded the entire thing.
Okay, so let's unpack this a little bit. The material really gives us two powerful case studies. First, you have the 2008 plea deal in Florida, where wealth and influence just actively leveraged the legal system. And then second, you've got the 2019 incarceration at the Metropolitan Correctional Center, the MCC, in New York.
Which is a story of bureaucratic decay, just rot, allowing for the ultimate lapse in accountability.
And the sources for each are so different.
Totally. We have these Bureau of Prisons records, shift logs, medical forms, internal reconstruction memos that show you the inner workings of a federal prison system completely under stress.
And on the other side?
Then we have these historical investigative documents, FBI transcripts, these incredibly critical letters from local police, detailed court filings.
Yeah.
And they all show the pressure points inside the justice system a full decade earlier.
So the guiding principle for us here, then, is to treat these ordinary documents, things like a daily security log, the record of a $100,000 donation, notes from a plea conference.
To treat them as silent witnesses?
Exactly. They quietly record these extraordinary crimes and then the subsequent profound failures of justice. We are looking for the exact points where the machinery of justice just bent and then ultimately broke right under the weight of influence.
And what you're going to see is that power doesn't just corrupt. It creates a completely frictionless path through legal and custodial obstacles.
Yeah.
And the irony is, it's all logged in the mandatory paperwork that was designed to ensure compliance in the first place.
So let's begin with that first system failure, Florida 2008. The very first data point we come across is so jarring that it basically defines the whole episode.
It's the contrast, isn't it?
It's the stark contrast between the punishment for the powerful figure and the punishment for his subordinate, his house manager.
This comparison is, it's an immediate indictment of the system's priorities.
Yeah.
The source material highlights it right away. Alfredo Rodriguez, Epstein's house manager, was sentenced to 18 months in federal prison for obstruction of justice. Meanwhile, Epstein himself was allowed to serve only 13 months in a county jail.
And even that's not the full story.
Right, mostly on work release, meaning he was out and about during the day for the underlying sex crimes he actually pleaded guilty to: soliciting a minor for prostitution and felony solicitation.
You have to stop right there. The system essentially said that lying about a list of names is a greater crime deserving of a longer, harder sentence than the actual actions those names were related to.
Yes.
We have to detail Rodriguez's crime because it speaks volumes about what was being suppressed.
Okay, so Rodriguez, when he stopped working for Epstein back in 2005, he took a bunch of notes and emails about the massage appointments.
Okay.
When state investigators later asked him if he had any documentation, he denied it. That denial, that lie, was the basis for his obstruction charge.
But then he changes his mind.
Or he sees a financial incentive. In 2008, he tries to sell those exact same notes to an undercover FBI agent for $50,000. And he refers to the documents he has as the Holy Grail.
The Holy Grail.
Or the Golden Nugget.
And the FBI special agent's affidavit confirmed what he was holding back. What exactly was in this Golden Nugget?
It had names and contact info for material witnesses and, crucially, additional victims. The sources note that these potential witnesses were spread out everywhere: New York, New Mexico, even Paris.
So it confirmed the operation was transnational long before 2008.
Absolutely. So by withholding that information, Rodriguez was actively crippling the state's investigation.
So let's just get this straight. The subordinate who has the evidence that could have blown the whole case wide open gets locked up for a year and a half, while the principal orchestrator, who benefits from that evidence being suppressed, is basically walking free shortly after.
The value system of the judiciary was made crystal clear. Protecting the powerful was more important than pursuing the underlying crime.
And that context makes the internal friction, the fighting within Florida law enforcement, so much clearer.
Oh, yeah. The documents reveal this immediate sense of alarm among local officials about how the state attorney's office was handling the case.
You're talking about the police chief.
Palm Beach Police Chief Michael Ryder. He was deeply frustrated. In a May 2006 letter that's in the source material, he describes their handling of the case as highly unusual, and he's bluntly critical.
He was basically hitting a brick wall. He could sense this institutional reluctance to prosecute, vigorously. The whole system seemed to be stalling.
And that frustration led him to take a really extraordinary step.
He requested a federal investigation.
He did. He recognized that the local resources, and maybe the institutional will, were just not sufficient, or maybe compromised.
And what happened next pretty much confirms all his fears.
It does. The state attorney's office took what was called an unprecedented step. Instead of just directly filing charges against Epstein, they presented the evidence to a grand jury.
And why would they do that?
Well, their official reason was that they had questions about the credibility of the girls involved.
Of course.
But what that move really did was slow the entire process down, create doubt, and it opened up a window for the federal authorities to step in and ultimately to cut a deal.
And here's where it gets really interesting. This internal conflict, the stalling, the doubt being cast on the victims, it all just paved the way for that extraordinary non-prosecution agreement, the MPA.
The MPA. This is the legal maneuver that allowed the system to just sort of neutralize itself. It was the legal firewall.
Federal prosecutors just agreed to drop serious federal charges.
Charges that could have meant a life sentence.
In exchange for Epstein pleading guilty to those two much less severe state charges. The documents detail how the potential for a life sentence just evaporated because of this one single agreement.
But how the deal was finalized and sealed is just as critical. The court documents show that the decision to seal the federal deal wasn't made through any standard, transparent legal process.
It was done how?
It was done during a plea conference. A judge, a defense lawyer, and a prosecutor literally huddled at the bench and made the decision privately.
Which violates Florida rules.
Completely. Florida rules require public notification for sealed court documents. A judge is supposed to find a significant reason for keeping records from the public, and that decision has to be transparent. That visual detail in the documents, the huddle at the bench, it's a metaphor for the entire process.
Accountability decided in a closed, intimate circle of power.
Exactly.
And when you look at the legal network Epstein had, it's clear this was no accident. The documents detail this team of high-profile veteran attorneys. We're talking Dershowitz, Black, Lefcourt.
Masters of hardball legal tactics. Their whole job is to manage the perception of truth through legal procedure.
And you can see that strategy perfectly in Attorney Roy Black's arguments later on.
Absolutely. He argued that all the correspondence about the plea bargaining was classic work product.
Protected by attorney-client privilege.
Right. He said any statements made during plea bargaining were immunized.
That is the language of evasion right there. It's basically saying we're operating within the legal rules to discuss how to limit the damage, and you can't see the details of our strategy. It's a shield.
A shield used not to prove innocence, but to dilute culpability and block any public scrutiny of how they got to that MPA.
And that legal insulation, it extended into some really aggressive tactics. Things designed to undermine the investigation and intimidate the victims.
Police Chief Ryder's deposition really provides the documentation for that. It shows how this legal machine applied external pressure.
Yeah, the sources detail this incredibly cynical strategy where Epstein's attorneys allegedly forwarded compromising details about the victims.
Pulled from where?
Pulled from things like their Facebook or MySpace pages, or from reports claiming they worked at places they called Jack Shacks or massage parlors.
And they sent this directly to the state attorney's office.
Directly. The intention was transparent. They were trying to weaponize the victims' backgrounds.
Which plays right into what the state attorney's office had already said.
Exactly. They'd already cited questions about credibility as a reason to use the grand jury. These details were designed to confirm those doubts, giving them legal cover to minimize the charges.
And the pressure wasn't just on the victims, it targeted the investigators themselves.
Right. Chief Ryder noted that both he and his detective, Joe Reckery, became aware that they were under surveillance for several months.
That's not just passive observation.
No, it's an active display of power. It's a signal that the investigators themselves are being watched.
And Ryder even considered filing witness tampering charges, didn't he?
He did, after a private investigator who was linked to Epstein's lawyers allegedly claimed to be a police officer to a victim or a witness.
Just think about that for a second. The local police chief felt he needed to file charges against the people who were investigating his own investigation. It just shows a system completely compromised by fear and influence.
So if we summarize that first failure, it was an active, deliberate dismantling of the criminal process. A high-powered legal team leveraged every single loophole.
Sealing documents, undermining witnesses, that unprecedented plea deal.
To turn a potential life sentence into a few months of low-security confinement. The paperwork confirms it. Accountability was actively defeated by strategic maneuvering and just overwhelming wealth.
And now we have to transition from that legal battlefield to the operational reality of it all. We need to look at the global paper trail, the flight logs, the financial records, to really understand how this shadow network operated and the sheer human cost of the enablement that came after that legal victory.
Okay, so we're shifting focus now. We're moving from the courtroom paperwork to the documents that detail his day-to-day operations. This is the shadow network that ensured he had access and, movement without friction.
And to do that, we have to use the powerful and frankly disturbing testimony found in the source material, specifically from Virginia Roberts, who is identified as Jane Doe 102 in the civil filings.
Her account is really the critical human link in this whole chain of systemic failure.
It is. It details the cold mechanics of recruitment and grooming. The documents confirm she was recruited by Ghislaine Maxwell when she was just 15 working at Mar-a-Lago.
And she was hired as Epstein's personal masseuse.
Yes, but the records also show she was paid extra to actively help recruit other girls. So she was both a victim and, tragically, an instrument of the system itself.
The psychological cost she describes in her accounts is just devastating. She talks about taking Xanax.
An escape drug, she called it.
An escape drug, trying to detach from the reality of her situation. She reported sometimes taking up to 8 pills a day. I mean, that just illustrates this desperate need to self-medicate and cope with the pressure she felt to please these powerful men.
And she points to this specific moment, her wake-up call.
Right.
It was when she realized the whole arrangement wasn't a relationship at all. It was strictly financial. It was based on a monthly payment plus a percentage of his income.
It's the commodification of trust and vulnerability, the dehumanization that allowed the whole enterprise to thrive.
Absolutely. She described telling Epstein she wanted to get her massage credentials first because she recognized that if she refused him, she'd be thrown back on the streets. She understood how precarious her position was. The power imbalance was total.
The Bureau of Prisons Reconstruction report, it notes something interesting. It says Epstein's identity appeared to be based on his wealth, power, and association with other high-profile individuals.
And that connection between his identity and his network is key.
Because his entire enterprise was tied to his ability to move across borders with zero friction. The flight and travel details in our sources, they act like silent witnesses to this global scale.
Absolutely. The records show, for example, there was a 6-week trip in 2001. Virginia was 17 at the time.
Okay.
Epstein invited her to come with him, ostensibly to meet architects and decorators for his house in New Mexico. But the trip became this global tour: Paris, Spain, Tangier, and finally London.
This wasn't a vacation.
No, this was the deployment of a human asset across continents.
Yeah.
It demonstrates his absolute control and his unlimited mobility.
And the London encounter really puts a fine point on the access the system gave him. Virginia confirms she was flown to London specifically to meet Prince Andrew.
And the preparation for that meeting. That's where the absurdity of the wealth and the scale of the operation becomes so visible.
You mean Maxwell's role?
Maxwell's role in managing the logistics, the aesthetics, it's all documented. She took Virginia shopping for designer clothes, including a 5,000-pound bag from Burberry.
A 5,000-pound bag.
It's a detail that just sticks with you because it represents this absurd investment in just surface-level presentation. And then Virginia was explicitly instructed to be smiley and bubbly because she was going to dance with a prince tonight.
It's not just the money, it's the choreography of it all. It's the use of luxury goods and global travel as stage dressing for exploitation.
And her subsequent civil writ made it explicit. It alleged her duties for Epstein included being sexually exploited by Epstein's adult male peers, including royalty.
The logistics of that, flying a minor across continents, managing high-end purchases, scheduling meetings with global figures, it all just points to a finely tuned operation.
It was a system designed purely to facilitate access and enable exploitation for his powerful network. And it was all bankrolled by this unlimited cash flow. The money wasn't just for luxury, it was the lubrication for the entire machine.
Let's look at how that financial enablement worked on the ground back in Palm Beach. The house manager, Alfredo Rodriguez, the same one whose obstruction conviction we talked about,
Right.
he testified in his deposition for the civil suits, and he revealed that he was instructed to keep a constant buffer of $2,000 in cash on hand at the house.
And that cash had a specific purpose.
A very specific purpose,
Yeah.
to pay the girls and the recruiters who brought them there.
That $2,000 buffer is just a stunning bureaucratic detail. It implies frequency, regularity. It implies an expectation of constant transactions.
It wasn't a one-off withdrawal. It was a permanent line item, a business expense.
Right.
It shows the daily, mundane, transactional nature of the abuse.
But the influence went beyond just cash payments. It targeted local institutions directly.
The documents confirm that Epstein allegedly gave large donations to the Palm Beach Police Department, including one for $100,000 for sophisticated equipment.
And, critically, the source material notes that police chief Ryder, the same man who was so critical of the state attorney's office,
He ordered that $100,000 returned immediately when the investigation began.
right, which is a moment of professional integrity you see recorded in the documents, but it just underscores how pervasive the use of wealth was to try and create this zone of immunity.
And the clippings allege even smaller, more insidious things like giving PBPD baseball hats for his car dashboards.
To avoid being stopped or ticketed.
Exactly. Whether it's true or not, the fact that it was an accusation highlights this pervasive assumption that wealth should just grant you immunity from routine scrutiny.
So the shadow network was highly efficient, well-financed, and globally mobile. It was protected by legal firewalls in the courtroom and lubricated by cash on the ground. The records we have, the flight details, the payment logs, the donation receipts, they all testify to a system that treated accountability as just an optional obstacle.
Which makes the transition to the 2019 failure so much more jarring. Because in 2008, the system was actively dismantled by legal maneuvering. In 2019, we see what happens when the system is just passively allowed to decay.
So we pivot now to the Metropolitan Correctional Center, MCC, in New York, a maximum security federal facility. This was the institution that was supposed to contain him to ensure accountability after his 2019 arrest.
And what we find in the internal documentation is just a portrait of severe institutional neglect.
What's fascinating here is we're not looking at clever legal evasion anymore.
No.
We're looking at the failure of fundamental bureaucracy. The logs, the memos, the maintenance reports, the mundane paperwork of compliance because the irrefutable evidence of non-compliance.
And that paper trail begins immediately with that highly scrutinized incident on July 23, 2019.
Let's just review the timeline for the medical records. At 6:20 in the morning on July 23rd, the medical assessment documents the injury. It says, injury unspecified, T1490, current RO, self-inflicted injuries.
RO meaning rule out.
Rule out. The plan was immediate, follow-up, and placement on suicide watch. The daily lieutenant's log records this placement at 1:40 that morning.
And a separate email from later that morning noted that an inmate companion reported Epstein claimed his throat was swollen. All of this points to a severe incident that should have triggered weeks, if not months, of rigorous, continuous monitoring.
Yet the documents show he was taken off suicide watch with remarkable speed.
How quickly?
The inmate history log shows he was cleared the very next morning, July 24th, 2019, at 8:45 a.m.
Less than 36 hours.
Right. And a follow-up email noted that he was assessed as not depressed or anxious, had no signs of distress, and his immediate plan was to go meet with his attorneys.
The speed of that removal is alarming, and it points directly to a crucial finding that's documented in the internal MCC reconstruction memo.
Which is a failure by executive staff to recognize the unique risks associated with this particular inmate.
The memo has this almost astonishing admission, a total blind spot. It states that executive staff acknowledge they may have inadvertently overlooked the need to consider unique risk factors associated with individuals who have been charged with and convicted of a sex offense.
To admit you failed to consider the unique risks of a high-profile defendant charged with multiple sex offenses in a major federal prison.
Yeah.
I mean, that suggests a systemic complacency at the highest level of MCC management.
But the decay wasn't just managerial oversight. The logs show it was structural. It was endemic to the facility's basic operations. The administrative paperwork itself was fundamentally broken.
An internal audit, which is documented in our sources, it exposed multiple severe deficiencies in security documentation across the entire facility.
Like what?
Well, look at the details. The attorney log, meant to track every single legal visit, was often illegible and consistently missing the required inmate register numbers.
So you can't accurately trace who visited whom.
Accountability vanishes. And the random visitor logbook for all other non-legal visitors was found to be missing documentation of visitor pat searches after May of 2019.
For months. In a maximum security facility, missing pat search documentation for months is an open door for contraband, for massive security compromise.
And it gets worse. The law enforcement logbook frequently failed to document officer departure times, which makes tracking personnel movement and ensuring adequate staffing impossible. And critically, the audit noted that a visitor denial log, a mandatory record detailing why someone was turned away, was never even created.
So these aren't just clerical errors. These are holes in the security infrastructure so big they compromise the very function of a detention facility.
They show that the system's primary job, to keep records and follow protocol, was collapsing before anyone even realized it.
And compounding all this were fundamental staffing issues, which are documented tragically in the shift logs themselves.
The records show all these personnel actions that just speak to a system under severe stress, just hemorrhaging staff and capacity.
We see staff listed as on LWOP leave without pay and even AWOL, absent without official leave.
In a high-stakes environment like MCC, AWOL staff means mandated security posts are unmanned. That's not just an HR problem, it's a catastrophic security lapse.
And the logs also show frequent cancellations and bypassing of overtime assignments. Posts like the SHU, the Control Center, 10 South, the areas needing the highest vigilance, were frequently listed as having OT assignments just dropped or avoided.
This documented lack of proper staffing and reliance on inadequate coverage. It explains why following basic protocols like the required 30-minute observation rounds for high-risk inmates became virtually impossible. The bureaucratic decay translated directly into a fatal vulnerability.
Which brings us to the most disturbing part of the documentation: the limitations that were imposed on the internal reconstruction after the August death. It further compromised any hope of real accountability.
The MCC interim report explicitly noted these severe limitations right from the start, and the most critical limitation was a mandate. Formal interviews with staff were explicitly not conducted as part of the internal reconstruction.
And that raises a huge question. How do you audit a failure of human supervision without talking to the humans who were supposed to be supervising?
Well, the answer, according to the report, was to avoid interfering with the pending FBI and Department of Justice investigations. But what that really did was prevent the facility from engaging in any immediate comprehensive self-assessment.
And then there's the issue of the physical evidence, or the lack of it.
The report states the single most critical limitation, and I'm quoting here, "There was no such video in this case since the original video was confiscated by the Federal Bureau of Investigation, FBI, prior to the beginning of this reconstruction."
That detail is just devastating. The MCC reconstruction team, whose whole job was to figure out how this failure happened, was denied access to the primary objective record of the event, the surveillance footage.
The absence of that video and the ban on formal staff interviews meant the reconstruction team's ability to establish accurate timelines, confirm subjective reports, or discover new areas of inquiry was severely limited.
The removal of the critical evidence, whether it was for procedural reasons or not, it just crippled accountability from the very start. The system that was supposed to investigate the failure was essentially operating blind.
Or at least with one hand tied behind its back.
So what did this limited, hampered reconstruction actually conclude? What did it recommend?
The final recommendations basically just confirmed the prior laxity. They included mandatory enforcement of single celling and rigid adherence to the required 30-minute rounds.
These are procedures that were already supposed to be happening.
They're stipulated in the Correctional Services Procedures Manual. The fact that the facility was forced to recommend following its own mandatory procedures is the most damning proof that those procedures were not, in fact, being followed beforehand. The documentation of the system trying to fix itself is, ironically, the proof of how deep the failure was.
So if we connect this all to the bigger picture, this entire paper trail From the sworn depositions in Florida to the security shift logs in New York, it consistently reveals that Jeffrey Epstein wasn't just an isolated criminal.
He was a node in a system.
Yes, a beneficiary of two very distinct but connected types of institutional failure. And that system just repeatedly protected him and failed to ensure any accountability.
The 2008 failure was active. It was strategic. Legal, police, and prosecutorial systems all minimized his crimes. The paperwork shows how wealth was used as a tool to actively defeat justice.
Through that non-prosecution agreement that violated protocol, through leveraging attorney-client privilege, through tactics to compromise investigators and victims.
But the 2019 failure was passive. It was bureaucratic. It shows what happens when power is met not with fierce opposition, but with just sheer institutional decay. A maximum security facility plagued by chronic understaffing.
AWOL staff canceled overtime.
A shocking disregard for basic safety protocols evidenced by those illegible and deficient logs, and a critical failure of oversight by managers who just overlooked his high-risk profile.
What stands out in the final tally is that in both cases, the system designed to uphold justice ended up collaborating with the powerful figure.
Either through aggressive legal maneuvering or through passive documented negligence and the literal disappearance of critical evidence, like that confiscated surveillance video.
The justice system, in both its prosecutorial and its correctional phases, just proved incapable of holding this level of influence accountable.
It's truly amazing when you reflect on the nature of these sources. The documents that were meant to detail procedure and compliance, the shift logs, the medical forms, the audit notes, they end up detailing the slow, bureaucratic erosion of justice itself. They don't just record a crime, they record the specific mechanisms of the failure to prosecute and, later, the failure to contain.
We have to realize that the most damaging evidence might not even be the shocking crimes themselves, which are horrific. It might be the utterly mundane administrative failures and legal evasions that are recorded in the paperwork that allowed this immense power structure to flourish without any friction for decades.
The system didn't fight back. It recorded its own surrender in triplicate.
The system, when faced with overwhelming wealth and influence, repeatedly failed to apply its own rules, and the paper trail confirms this institutional negligence down to the minute. So for you, the listener, the provocative thought is this. If the evidence of systemic failure, the missing logs, the canceled rounds, the closed-door deals, is all recorded in the system's own handwriting, how do we force that system to finally look at the documents it creates and demand accountability?